Case on this morning's docket. Case number 118120, State of Kansas v. Sherman Jenkins.
Please support counsel. My name is Corey Call. I request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. I'm representing Sherman Jenkins. A truck was stolen, and the police saw that truck driving down the road. They activated their lights, and they pursued it, and eventually the truck ran a red light and T-boned a car, and a woman in that car was killed. And Mr. Jenkins was charged with a variety of crimes related to the chase, and also fleeing and eluding involving the chase, and then felony murder, which is a murder committed where a death occurs during the commission of a dangerous felony. Fleeing and eluding is such a dangerous felony, and and he was convicted of those charges at trial. We raised two issues. One related to some jail calls, the foundation for some jail calls that were admitted, and whether the fleeing and eluding statute, which was one of the basic, whether a portion of the fleeing and eluding statute was unconstitutionally vague. I'd like to start with the second issue. I think that's the more interesting issue of the vagueness of the fleeing and eluding. The statute has various ways in which the felony, which fleeing and eluding is elevated to a felony. And one of those is that the person commits 5 or more moving violations during while running from a police officer. And in State v. Richardson, the case was the district court did not instruct on what a moving violation was. And this court said that a moving violation is used in the fleeing and eluding statute is not common knowledge for jurors, because the statutes use different terms and regulations use different terms. Some statutes refer to the regs, this statute does not.
But jurors here didn't have that handicap, right?
That's right.
Because they got a specific instruction that said these things are fleeing and eluding, or fleeing and eluding.
That's right. I believe they took that. There's a reg. There's a reg
Right.
that lists these are moving violations,
Right.
and they use those.
And the instruction came right out of that regulation.
I believe that's correct. Yes. The problem here is that what we're arguing is that the statute is vague. In other words, as far as what a moving violation is. Because if it's not common knowledge for a juror to understand what the statute means by moving violation, the juror that citizen does not become imbued with that knowledge once they leave the jury box and get into their car. It's still, we don't know specifically what the legislature meant by moving violation. What Richardson said.
Why does it have to be the legislature? The legislature in KSA 8249 directed the Secretary of Revenue to define moving violations. And once that was done, and it's in a regulation which has the effect of law, why doesn't that take away the vagueness?
Well, and based upon Richardson, the problem is that the regs define moving violations differently, and they refer to different. And so if the term moving violations had been used consistently throughout the regulations to mean the same thing, or consistently through the statutes, then we read them as a whole, and that becomes a word which we know what it means legally. But that's not the case here.
But wasn't Richardson Kansas Corporation Commission versus revenue regulations?
I believe it also talked about the trucking. I think it was the commercial regulations, and also. But it referred to, in some sections, referred to that there are exceptions. In some statutes, they refer specifically to the regulations, and that sometimes there are exceptions to those moving violation regulations. And it's not clear that the legislature, and I think the question is, what did they mean when they said moving violations? And if they meant, they thought it covered from the previous section where they referred advised them to make regulations. Then they could have referred to that in this statute, as they do in other statutes. They talk.
Why do they have to? I mean, we don't make them refer back to the definition statute every time they use a word.
That's right. That's right. But where it means different things, where the term moving violation means different things, then the legislature needs to clarify what they mean by using it in this particular situation. And I believe that's what Richardson
It only
said.
means different things as between a passenger car driver and a commercial driver, right? That's the difference. And this case is not about a commercial driver. It's about a passenger car.
That's right. But I don't know that the term moving violation in fleeing eluding, I think it could still be qualified. I mean, it still apply to a commercial driver. That could still be. It doesn't apply in this case. It doesn't. But as far as what that term means in the statute and whether Mr. Jenkins would have understood what that term means, the term, I think the logic of Richardson still applies. The state's argument was that, well, the vagueness is to protect someone from innocent behavior, and this is all of these are criminalized or traffic.
I'm not sure that's right. I think you're confusing vagueness and overbreadth. Right. Vagueness is about fair warning to the reasonable person and arbitrary enforcement. That's all we care about on vagueness. It's not about capturing innocent conduct. That's overbreadth.
Oh, and I guess I was inartfully characterizing the state's argument, and because I think you're right. The question here is whether or not this statute adequately informs Mr. Jenkins of
Warns the potential offender and guides law enforcement.
That's right. It's this particular offense. The fact that it's
Can you articulate a concrete possibility of arbitrary enforcement under this statute?
well,
Like a what if, based on the definitions and the vagueness that you see in them?
well, I'm not sure I can. I'm trying to. I know there was, for instance, a moving violation. There's exceptions, and certainly it's law that if you drive in certain circumstances less than 5 miles an hour over the speed limit, that's not considered a moving violation under certain statutes. And certainly that's what we.
But is it considered a moving violation under other parts of the law?
I don't know. There's a statute that says it's not a moving violation for purposes of having your license revoked. That's what the legislature says in I believe it's that statute. So then the question is, does that apply to 1568? If you're going 5 miles an hour over the speed limit, is that a moving violation? Is
it defined as a moving violation anywhere else?
Well, I believe going over the speed limit, I believe that's in the list. I don't believe it was on the list that they gave, but I believe it's in the list. And the fact that they accepted out that particular portion for that statute, seeing that in some cases it would be. It's not for registration, but it is. So I guess I don't know if I brought that with me. I can check and maybe send a 609 letter to see if it's in that
I don't think they
Count.
listed speeding as one of its moving violations.
It wasn't in this case. It wasn't in the instruction. Whether it's listed in the statute, I would think it would be. Otherwise, they wouldn't need to specifically accept it out in that particular statute.
Counsel, can you tell us precisely how you would fix this statute so it would give fair warning to those potentially subject to it?
Sure. I think all the legislature would have to do is in 1568 say moving violation as defined in the KAR 92. Sorry, off the top of my head. That particular reg, and I believe in the fleeing eluding they have other definitions. This means this, and they just put moving violation means as defined in the statute, and that would clear it up.
But again, we don't do that in lots of criminal statutes. We have terms that are defined in an introductory subsection. We don't say as defined in
Right, and I
21-101.
think it is usually the case, hopefully it is always the case though, that that term is used consistently throughout the statute. If it's defined someplace and it's used in the same way in every statute, then you don't have to refer back to it because you know exactly what it means because it has that definition. The other problem, is the remedy and whether or not this is harmless. And the state raised the Castleberry case, which talked about that these are that the different ways of committing fleeing and eluding, of elevating fleeing and eluding, are options within the means as opposed to alternative means. And there were other options given to the jury in this case, and there was evidence of those, and we didn't allegedly fault with those. The problem with the analysis, I think, is there's a difference between what I think of a state v. Wright analysis of whether is there sufficient evidence of two means, and in which case there's a problem if there are alternative means, and therefore they're both elements of the crime, or if they're options, then they're one element. And in those cases, there's not a problem with the insufficient evidence of a particular mean, because the question is there sufficient evidence of this element? And if there are options within the means, then there's sufficient evidence of that element. So there's nothing improper going on. In this case, if we're correct, there was an unconstitutional basis upon which the jury could have relied, which it could have based its verdict. And therefore, there is something improper here. And we don't know. The state can't say whether or not they relied on that particular option.
I understand what your argument is. I have another question, though. Aren't you overgeneralizing when you say that the jury was instructed on multiple options within a means for fleeing and eluding? Because they were on the second pursuit, but not on the first, right? On the first one, they were only instructed on moving violations, right?
That's right. That's right. Yes, that's exactly right. Yes, you're right. And so for that, it would be for that one, it would be that's the only option, and that would go away.
Okay.
I guess I was
So
thinking
if
mostly
we-
about the felony murder, because the felony murder was based upon the second.
Right.
I'm sorry.
So your ultimate point is that if we were to agree with you on vagueness, on any basis, that both the felony murder conviction into which the second pursuit was merged and the standalone fleeing and eluding for the first pursuit would all have to be reversed.
Yes.
Okay.
Would you just provide for us the means to how we reach this question? It wasn't raised in district court. What's your exception you're wanting us to apply to reach this issue?
Well, that it was it's a legal question. There are a lot of facts required for this. Yes, there are several exceptions. One or not three. One is that it's a question of law, which would be determinative of the case, which is the case here. It's if this court found it was vague, that it would turn the case and give it a trial. The second is that it impacts fundamental rights, and a vague conviction resting upon a vague statute violates the due process clause, which violates his fundamental rights.
Are you going to address the other issue?
Just briefly, I don't know that there's a lot. I think it's pretty well covered in my brief. There's the phone calls. The question was there were some jail calls that were recorded, and the only way they identified the calls as being from Mr. Jenkins were the inmates are given a personal ID code, and that code was typed in before the call.
But that isn't the only evidence in support of that. Let's review. Certainly the PIN was part of it, and they had the particular officer who was familiar with the recording system at the jail testify that he was given this PIN and that he
Right.
checked, and this PIN is what was activated. No one identified him by voice. No one identified him by name during the call. But am I right that the district judge listened to the recording out of the presence of the jury initially, correct?
Correct.
And I'm also correct, or am I not, that under any test, the identification of the speakers can be proved by circumstantial evidence.
Yes, I believe that's right. Yes.
Okay, like almost everything else, circumstantial
sure.
evidence is sufficient.
Yeah.
So in that call, the actual content of the call, the male speaker is talking about the scenarios that occurred here. The first chase, the abandoning that car, the second chase, I guess that was actually the first one was a van, the second one was stealing the pickup truck, ending up in an accident at 6th and Topeka Boulevard, and a woman being killed. All of that was talked about in the calls,
Correct.
right? And the only person they pulled out of the car, or excuse me, pulled out of the stolen pickup was the defendant in this case.
That is true.
So isn't all of that circumstantial evidence that he is in fact the person on the call? And all of that came in before the judge allowed the jury to hear the calls.
That's right. I think that is putting the cart before the horse a little bit to say that because he talked about, the question in the trial was who was the driver of the car? And there was,
Was that really any legitimate question, given that he's the only person that all of those officers observed speeding into that accident and then removing from that vehicle?
I don't know what else the question of the trial was. The whole thing was on videotape.
Exactly.
And so, and I understand I have a harmless error problem on that if you take out the confession, but I have a real problem with saying, well, he admitted to all of the all the events of the crime, therefore that shows it's him, when the purpose of the calls is to say that he admitted to the thing to prove that he was the guy. That seems problematic to
I
me.
understand it seems logically circular, but in fact, isn't a judge permitted to consider the content of a call that's been recorded as part of the calculus on the identity of the speaker?
Absolutely, but I think that the judge shouldn't use the fact that this is the person who committed these crimes, and he's describing the crimes as support for finding that he's the person on the call.
I think you're oversimplifying. The judge is not using the fact that he committed the crimes. He's using the fact that the person on the call knows all these details about the crimes, which often is circumstantial evidence of guilt. We
Sure.
do that all the time, don't
Right.
we?
Yes.
Somebody who knows something that was never published by the law enforcement, right?
That's right,
And that's
yes.
exactly what this is. He knew facts about what had occurred that only the perpetrator would know.
Or someone who talked to the perpetrator. Or that's right. But you have to assume that he
But
is
the
the
person who
perpetrator.
talked to the perpetrator wouldn't say, I was involved.
That's true. That's true. And
Okay.
so, but yes.
Okay, thanks.
Any further questions? Thank you, counsel.
Thank you, Your Honor.
Mr. Chief Justice, and may it please the court, the state of Kansas appears by Stephen Obermeyer. If I could address the issue we just finished up on first, I think to adopt the defendant's theory, we would have to believe that the defendant, once he went into the jail after he got out of the hospital, received this PIN number, personal identification number, to make phone calls, and he gave it to another inmate, and this other inmate
I think
started making...
Justice Byers' inquiry was how far beyond that can we go to validate that that is the person that's been assigned that particular PIN number, and can the content of the phone call be a part of that calculus? If you get,
Yes.
because of the acknowledgments that were made about specifics of the crime, can that be a part of the calculus?
If you look at the Sangster case, Justice Rosen, out of Illinois, the court looked at the contents of the phone call and looking at the foundation issue. But I think there was sufficient foundation just based on the PIN number, and a prima facie level was reached as far as admitting the exhibit, and it goes to weighted not admissibility at that point.
In
And-
Sangster, was there any mention of the name of the alleged perpetrator in the call? I just remind me of the
Yes,
facts.
Boz was a name that was mentioned, which was consistent, I think, with one of the...
Okay, so that's
the
really
witnesses.
distinct from this, because here the woman on the call never says his name. he never says either his first or last name, right?
As I
We don't
recall-
have anyone, and then of course, obviously, we don't have anyone overhearing the call at the time, at the time of the call, right? Calls.
Correct.
We have
Correct.
multiple calls here.
As I recall, Justice
I mean,
Breyer.
that distinguishes Sangster, doesn't it? In a way, there's more than mere circumstantial evidence in Sangster, in a way.
In a way, the girlfriend on the calls here is referring to him as Ricky, which is his nickname,
Oh,
and that came out
in our case.
Yes.
I didn't
his
realize that. I
name
thought
is-
there was no reference to his name.
I think the name, nickname Ricky was mentioned in the
Okay.
phone calls.
Was there other testimony to support that that was his nickname?
I don't recall if that did come in. But I think the jail process, as far as being booked in, you're given a personal identification number. It's the day after the accident, and he's making a call talking about this particular hit and run.
Does the record tell us what time that day, or what the time of his release from the hospital?
I don't recall from Officer Biltoff's testimony if
We can check it.
Okay,
That's
but
Thanks.
it's in volume 12, starting at page 531, but it was the day after, and I think it's the first opportunity that he has to make phone calls. And so he's calling a significant other. And it looks like the length of the calls are 5 minutes because there's 4 or 5 of them right after another. But as far as whether the
Counsel,
district...
are you suggesting it's not a mere coincidence that the day after the accident, somebody made this phone call and talked about the details of it?
I'm suggesting, yes, that's not a coincidence, and that we shouldn't believe that he gave his PIN to somebody else to do this, and this isn't a Matlock case where we're going to come in with somebody else.
Was there evidence introduced as to the relationship between the defendant and the person that was called?
I think there was a Detective Shearer.
You referred to her, I think, as significant other.
Yes.
Was that was introduced in evidence? Because
I
that would tend also to be some evidence of the identity of the caller, would it not?
Correct. I think the detective, this is starting at page 612 of volume 12, talks about having listened to the recordings. And as I recall, there was a reference to the name, Constance Rodriguez is mentioned.
That's Bill Toth. That's not Scherer, right?
Well, Shearer's,
Scherer's much later, and I don't think you can rely on Scherer's testimony to lay the foundation for something that went before the jury before he testified.
the tapes were not played until Shearer testifies.
Are you positive? Or Bill Toth, I think you're correct. I'm not sure that's correct about Scherer.
As I recall, the judge ruled that it would be admissible when Bill Toth was on the stand.
Right.
And then the prosecutor said, I'd like to wait until later to publish these to the jury.
Okay.
And then we have the detective at page 613 talking about the 6 jail calls made to Constance Rodriguez, refers to a female. I thought it mentioned that it was a girlfriend or something like that in there,
But
it
you're
was
not seeing that, the relationship between the two.
As far as the testimony from the detective, if it's not in there, it's not in there, but it certainly, I think that.
Just
both-
trying to pin down what are the discrete pieces of evidence that support the identity of the caller. I know obviously we have the PIN number.
Right.
And the timing of the call you mentioned.
Right, PIN number, timing of the call.
But maybe we can't rely on the relationship between the two on the phone.
I thought there was some evidence talking about relationship in there. They certainly had her name, but I'm not saying the relationship right offhand. But
Do you think the way, for lack of a better way to phrase it, the Williams factors that were established in the mid-'80s when it comes to recording, the admissibility of recordings is a good test to use today? I mean, that was back when it was a reel-to-reel, multi-track tape system. Now that we have digital kinds of technology, is it should we expand on those? Are those just good baselines to use? What do you think about that?
I was suggesting a different test, Justice Rosen, because Williams relied upon a section, legal encyclopedia, as far as where they got that.
Right.
That encyclopedia has even changed
Right.
its definition.
I mean, is it antiquated, do you think?
I think it is, where you have the 7 factors and the listener compared it, and it doesn't address a situation where you have a silent witness, which is what this is. We don't have a witness to say that's the voice on this. We can talk about the reliability of the recording system and how they use the pen to access the recordings, and this is where it is, and that's the silent witness line of cases would not be covered under Williams. I don't think so.
What test would you ask us to replace with?
The one I put in the brief, I don't know if it was under Sangster, but I'm not finding it right offhand, just
Fine.
but something under the silent witness rule, and I know I cited the treatise on evidence, McCormick on evidence, would also be supportive of that. But when it comes down to it, is this purported recording what the proponent says it is? And even based on the Penn and Officer Biltoff's testimony, I think there's not an abuse of discretion by the district court.
Sangster had
Presumably
5
the-
factors. Is it the 5 factors from Sangster? There were 5 factors in Sangster.
I think that
Okay.
was it.
Presumably, the trial court had heard the defendant's voice. Is that a basis the trial court can use? The trial court's own ability to compare the voice on the recording to the voice of the defendant?
The trial court listened to the first 2 recordings. I didn't catch that the court was making some sort of comparison or not. Under Mr. Call's theory that you have to identify the voice, I guess the court could make the defendant say some words in court, and then does that sound the same or something? But I don't think I didn't read it as a trial judge doing that. I don't think you have to do it that way, and they couldn't find the girlfriend to call her. That would have really taken away an issue here. I just didn't catch that as what was going on. So, if there's no other questions on the first issue, then moving on to the second issue, I think as far as what a moving violation is, I don't think it has to be in the statute, but it has to be somewhere where a reasonable person could understand what the law is, and it is set out in the Kansas Administrative Reg 92-52-9A. And during the closing arguments and during the testimony of the officers, the prosecutor would stop the officer and say, is that a moving violation? The running of the red lights, the stop signs, and all that. And in the KER, those are all listed as moving violations, and it becomes an issue if you go to traffic court and you want to know if it's going to impact your license, because if you get a certain number of moving violations within a period of time, you can get a suspended license, which Sherman Jenkins was on at the time he was driving. So there are other options within means of having committed the fleeing and eluding. He drove around the stop sticks, engaged in reckless driving, was involved in a motor vehicle accident. As you can see that by the fact that the other 2 victims were victims of aggravated battery, and the jury found aggravated battery. So even if the court does address the issue on constitutionality and determines the statute's unconstitutional, I think that would be a harmless error under the Castleberry argument.
I'm not sure that Castleberry works for you.
Okay.
Do you have a case that tells us that if one of the options within a means is unconstitutional, but there's sufficient evidence of other options within a means presented, that you're fine? I mean, if that's what you're asking us to do with Castleberry, isn't it, to kind of extend it to a case we've never seen before?
Okay, Castleberry dealt with insufficient evidence as to
Right.
that
And
option.
aren't you suggesting to us that even if we have a constitutionally infirm option within a means, so you're assuming we agree with the defendant on
Right,
vagueness.
right.
So we have a constitutionally infirm option within a means, that we can just ignore that, even though some portion of the jury may have relied upon it to convict. Isn't that what you're asking us to do? And this is, again, assuming we've gone on the merits with your opponent.
Right. I don't think I'm asking you to do that because you had the other evidence of you have the fact that he was involved in a motor vehicle accident and drove around the stop
Those are
sticks
the other options.
and
within
the other
means.
options.
That's what I'm asking you. So you're asking us to ignore unconstitutionality of an option within a means and just say, good enough, all's fair in love and war, we have sufficient evidence of these other options that were given to the jury. But we don't know, because they are options. In fact, it's even worse in this case because we not only have an options within a means situation, we have an unnecessary multiple acts instruction also given, which would tend to tell the jury you have to agree on the means, even though they didn't, right? We've got that problem in addition here. So we have this situation where we can't know what the jury relied upon to convict, right?
I think I still see it as the same as insufficient evidence of it, and that under Castleberry you could still apply.
Unconstitutionality is the same as insufficient evidence? They seem totally different to me.
And
You don't have a case that says they're the same.
I
No.
don't. I
Okay.
did not brief that
Thank you,
that
counsel.
issue. But I do think the fact that the jury found him guilty of aggravated battery ×2 has to occur with a motor vehicle accident in this case, and it's clear on the video that he drove around the stop sticks and engaged in reckless driving. I think neither Castleberry or Richardson, this court said that running red lights and stop signs is
Sure.
reckless
I
driving.
completely understand what you're saying, but we don't ordinarily substitute our judgment of the facts for the jury's judgment of the facts.
Right, but it'd be like if there was a felony murder and insufficient evidence as to one of the underlying felonies, but the jury found the defendant guilty of another felony count that was another option under the felony murder. I think is my argument. I don't have anything else.
Do you have any more questions? Counsel, what are you asking us to do?
I would ask you to affirm the defendant's convictions.
Thank you, counsel.
Thank
Hey, please, court. Just to answer a couple questions. As far as whether the Williams factors are out of date, I think it, excuse me, I think it depends on the factor in question. And here we're talking about whether the identity of the speaker is a relevant factor, and I don't think
That's the only factor at issue at this point, isn't it?
Yes, that's right. Yes, yes. And so I don't think the technology changes the reason for that particular, why Williams put that in there. They want to make sure that if you're saying this is the person that was talking, that is the person that was talking. And so I don't know that the advance, it may be relating to the competence of the operator or other technical aspects of it, but I don't think in this particular factor, I don't think needs, if you change the test, don't change that part of it.
I heard the state say that it was relying on the PIN number and the timing of the call as the two evidentiary bases for the laying the foundation of the identity of the caller. Why isn't that enough?
Well, it's...
We have case law saying the burden to authenticate is minimal, slight.
That's right, but it is something. And the
Well, but
time-
why isn't that enough? You've got a PIN number, which seems to me to be uncontested, and the call being made very soon after the time in which the defendant was actually capable of placing a call. Don't those two things, why isn't that enough, I guess, is back to
Well,
the
I
question.
think it's still, I think you still have to, the fact that the call is placed in close time, you have to look at the content of the call in order for that to be.
Why? Why do we have, who cares what the, I mean, just for the purpose
Sure,
of my
yeah, no, I
question,
understand.
why does the content matter? You've got a call placed with the PIN number that was assigned to this defendant, and the call is placed very soon after that defendant was actually capable of placing calls. And those two things together strike me as
Well,
enough to get across the slight threshold for authentication.
sure.
So
If-
convince me otherwise.
Well, I'll try. It seems to me that the timing of the PIN number, this PIN number was issued, and it seems unlikely that someone would randomly punch in the PIN number. And so the PIN number is, we can argue about whether that is alone sufficient. But as far as the timing go, it's still, I think it's uncontested that Mr. Jenkins was given that PIN number at a certain time. And shortly thereafter, this call was placed using that PIN number. That seems to make sense. Whether if the concern is that someone else took Mr. Jenkins' PIN number, then that's going to be the time most likely that that PIN number is going to be used is soon after he gets the PIN number.
The person who took it.
The person who took it, or the person that he gave it to, it's
So
going to
you're
be.
saying timing is negligible?
That's right, and it still comes back to the fact that this is his PIN number.
Except
we
that
were-
it was used multiple times. The PIN number was used multiple times. And what's the coincidence of that?
Well, I think once they were used to call the same person. So once somebody uses his PIN number to call this person, I think it doesn't add any relevance that they did it multiple times. That's the PIN number they're going to use to call that person.
You're suggesting that the judge could not look at the content of the conversation to make a foundation ruling?
No, I'm not saying that. I'm saying that the judge, if there are contextual clues to the identity of the speaker, other than the facts underlying the crime itself, I don't think you can use the fact that that the defendant committed the crime to authenticate it. But I don't remember them referring to the defendant as Ricky. I don't recall that. But let's say that was in there, and they established that this was a nickname. Well, that's a context that could be used. Or if he says, "My house over on Mulberry Lane," and the defendant lives at Mulberry Lane, well, then that's a contextual clue that you could use. But I don't think the fact that we know he committed these acts, and the speaker of the crime, and the speaker of the call, in first person, talks about committing these acts. Therefore, we know it's him. That seems that you're using the fact that he's guilty to introduce evidence of his guilt.
Do we have any further questions? Counsel, what are you asking us to do?
I'm asking you to reverse the convictions and remand for a new trial.
All right. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.